Really? I thought it was curious when you said that your company credo was to always put the public first.
It is.
Was that what you were doing when you were lying to doctors and patients about the addictive nature of opioids? Is that why your company agreed to billions of dollars in settlements with states and other localities because of what you did to further the opioid crisis?
We prevailed in the only 2 cases that were tried.
You settled for billions of dollars, and I brought one of those suits, and it's the proudest thing I ever did as Attorney General of the state of Missouri. Your company has made billions of dollars on American consumers, multiple times lying to them. And the idea that you now are looking actively for ways to limit the liability for further torts you have committed against the American people, I think is outrageous, absolutely outrageous. And if you want to know why the American people don't trust huge corporations, it's because of companies like yours.
Senator Hawley.
Thank you, Mr. Chairman. Mr. Haas, if I could just come back to you. Let me ask you about the Ingham case. I'm sure you remember that case. That was the one litigated in my state, in the state of Missouri. 22 plaintiffs who alleged that your baby powder caused ovarian cancer. By the way, didn't the FDA find that there were traces of asbestos in your baby powder?
The FDA outsourced to a lab that found asbestos, a trace amount of asbestos in one lot, and 150 studies thereafter were done of that batch and found no asbestos. And if there was asbestos in that...
Okay. That's quite the word salad. But if we just compress, I think the answer is yes, right? Did the FDA find that there were traces of asbestos in your baby powder?
No,
yes.
Ultimately...
No?
Ultimately,
the Third Circuit got that wrong? I just read it in their opinion.
Ultimately, if the...
Wait. Answer my question. The Third Circuit was wrong about that? I just read it in their opinion. They said the FDA found traces of asbestos in your baby powder.
The FDA outsourced to a lab that found a trace amount of asbestos.
Okay,
thereafter.
so the answer is yes. So let's go back to the Ingham case then. I think it's a relevant question. Do you remember what the verdict was in the Ingham case, where the jury found what they awarded?
As the chair properly stated, it was initially $4.6 billion for a consolidated trial of 22 plaintiffs that was reduced thereafter to $2.2 billion.
$2.24 billion finally on appeal. That's a lot of money. That's one case, 22 plaintiffs, 20 at the end of the day because of the appeal. You were facing how many additional cases after that?
We have thousands of cases.
Thousands, tens of thousands, right?
That's correct.
Okay. So one set of plaintiffs gets $2+ billion. You have the potential for, by that math, tens of billions more, right? Who knows
No,
what?
not necessarily, because recall, most claimants lose and receive zero.
So what you do is, after the Ingham case, your company panics, and what you do is you then decide, oh my gosh, we can't possibly do this. We don't want to pay these plaintiffs this kind of money. So you then create a separate company for the sole purpose of declaring bankruptcy and making sure that the tens of thousands of other plaintiffs get scraps.
The proposal that we had would never succeed and would not have succeeded but for the support of the claimants that had made the proposed resolution. We went to
I have no idea what you're saying. I thought it was plaintiffs who sued you that went all the way to the Third Circuit where they said you couldn't do what you're trying to do. You're saying that you're saying the plaintiffs wanted this? They like the Texas two-step? The plaintiffs want to be denied their day in court and denied recovery?
The majority of claimants, counsel representing the majority of claimants, yes, do want this resolution because most claimants receives nothing.
Let's talk about what you did.
That was an aberrant one-off
Let's talk about what you
verdict.
did. First of all, I think it's outrageous, the idea that plaintiffs want to be denied their day in court. That's why they took you to court. That's why the Third Circuit ruled against you. Let's talk about what you did. Here is, according to the Third Circuit, an abbreviated version of how you tried to avoid actually paying out liability. Old Consumer, which was one of your subsidiaries, merged into Chenango Zero LLC, a Texas limited liability company, wholly owned subsidiary of J&J, with Chenango Zero surviving the merger. Chenango Zero then effected a divisional merger under the Texas Business Code by which two new Texas limited liabilities were created, Chenango 1 and Chenango 2, and Chenango Zero ceased to exist. Then Chenango 1 converted into a North Carolina limited liability company and changed its name to LTL. Chenango 2 then merged into Curahee Holding Company, the direct parent company of LTL. Curahee survived the merger and then changed its name to Johnson Johnson Consumer Incorporated. Are you here to tell us that you think that this is a great way to proceed and is fair to the consumers who had asbestos in their baby powder?
Indeed, the claimants after that transaction had access to more recourse than they did before, which is exactly
More recourse?
which is exactly
You
the reason.
created, in the words of the Third Circuit, you created a company with the sole purpose of sending it into bankruptcy. So you could limit your liability. Here's what I don't understand. Johnson & Johnson is a hugely profitable company, isn't it?
This is where we're talking about a subsidiary.
Oh, I know,
was in
but
a
you own them
lost
all. You own
position.
them all. So aren't you hugely profitable? I mean, how much money did you make on the COVID vaccine, for example?
Nothing, actually. We made nothing.
You got
on it.
billions of dollars in subsidies from the federal government. Taxpayers have paid you billions. How much did you make on opioids? All those opioids you prescribed? How much did you make on that over the years?
I do not have that information.
Really? I thought it was curious when you said that your company credo was to always put the public first.
It is.
Was that what you were doing when you were lying to doctors and patients about the addictive nature of opioids? Is that why your company agreed to billions of dollars in settlements with states and other localities because of what you did to further the opioid crisis?
We prevailed in the only 2 cases that were tried. and
You
the
settled
jury
for billions of
determined.
dollars, and I brought one of those suits, and it's the proudest thing I ever did as Attorney General of the state of Missouri. Your company has made billions of dollars on American consumers, multiple times lying to them. And the idea that you now are looking actively for ways to limit the liability for further torts you have committed against the American people, I think is outrageous, absolutely outrageous. And if you want to know why the American people don't trust huge corporations, it's because of companies like yours. And I would just say to my colleagues, if you want to know why private rights of action are so darn important and why we need to use them against the big tech companies, this is the reason why. One jury verdict got $4.6 billion. That's a hammer. Companies fear it. They fear it. It's why they're trying to distort the bankruptcy code to avoid it. We need to give more Americans the ability to get that recourse in court. And we need to change the bankruptcy code to make sure that companies like J&J can't avoid it. Thank you, Mr. Chairman.
Thanks, Senator Hawley. Senator Kennedy.
Thank you, Mr. Chairman. Mr. Haas, you're with Johnson & Johnson, is that right?
Yes, sir.
How is that stakeholder capitalism working out for you?
How is it working for Johnson & Johnson? It's one of the greatest honors of my life.
Okay. I see where you, Johnson & Johnson, has joined with a number of other good American companies, J.P. Morgan. He's not a company. Mr. Colin Kaepernick on his issue of police brutality. Procter & Gamble, Facebook, Apple, y'all pledged $50 billion to, quote, be a force for social change and fight injustice. $50 billion is a lot of money. How is that commitment consistent with what you're asking us to do here today?
Sir, I'm not aware of the particular commitment you're referencing, but I could
It's right
say
here on the
dispositively.
internet. It's got to be right.
I could say dispositively that the consistency is, in the end, to ensure that each and every act that the company takes is consistent with our credo.
Okay.
And our credo puts the public and our patients first.
Right. Let me ask the professor a few basic questions because I'm still learning about this issue. Johnson & Johnson took it, before I do, I forgot to ask you one question. How many talc cases have you tried to verdict?
There have been 42 cases that have gone to verdict. Of those, we have prevailed in 32.
Okay, so you lost 10.
Yes.
Okay, and what were the total damages in the 10 that you lost?
The damages ranged dramatically.
Just give me a total.
I don't know the total. I can give you a approximate. The highest one was in the billions.
Okay. All right, Professor, I don't want to just pick on Johnson & Johnson, but they're the one here. Let me pick on Georgia Pacific. okay? I don't want to pick on anybody. I'm learning on this issue, but let's call them Corporation A gets sued with respect to mass torts. They spin off the liabilities to a shell corporation, and that shell corporation files Chapter 11 bankruptcy, right?
Sure.
Is that legal under the bankruptcy code?
Is that legal? The code does not restrict that necessarily. Courts have found that there are a variety of bases to reject that sort of action. So courts have been pretty active in this space. I should probably, Senator Whitehouse
what's
left.
What's the consensus? I mean, some bankruptcy judges say this is a legitimate use of the bankruptcy code, I presume. Other bankruptcy judges say, no, it's not, and it's dismissed. Is that a fair statement?
That is a fair statement. I think that there's a nuance here. If you don't mind, I can flesh it out a little bit.
What's the national consensus on this?
I think the national consensus is that this is a proper action under state law, but to the extent there is some sort of impropriety, bankruptcy court judges are very well positioned to police that, as we've seen in the LTL case. So it's not that Senator Whitehouse pointed out that I was supporting Texas two-step. I'm not supporting Texas two-step. I'm merely providing that
so
to the extent there is
has
malfeasance,
the
it can be
authority
addressed.
To say this is an abuse of the code, right?
Exactly.
And
courts can address
that. How many have done that?
Well, the most prominent one is LTL. So in the Third Circuit now, there's a very rigorous
test. Is there a
test.
split among the circuits?
There is. So the Fourth Circuit, and we were talking about forum shopping earlier, that would encourage forum shopping, absolutely.
Okay. Is there a case before the Supreme Court to resolve this?
No.
I bet there's one coming. I mean, and what are you asking us to do today? Let me start with Mr. Haas again. What are you asking us to do today?
The ask from our perspective to Congress would be to make uniform that very issue you just identified. What is the standard with respect to dismissing a case? Now, there's a distinction between the propriety of a Texas two-step, let's call that, it's a divisional merger statute, and the question of what is a standard that you apply when you dismiss a case. Our case was not dismissed because of anything to do with the Texas two-step. Nobody challenged the Texas two-step in our case. In fact,
Mr. Haas, you just had a golden opportunity to answer my question. Let me ask you, Mr. Parikh, and you didn't do it. Professor, tell me what you think we should do today. What you think Congress would do.
I think there are very large issues here. I think, as I mentioned before, 524G needs to be amended to capture all mass tort cases. Once that's done, you can have uniformity in process and procedure with all these cases. Some involve asbestos, some don't. The code can be revised to provide clarity on whether third-party releases can be part of a plan. I think that would be very helpful. And then, of course, the future claimants representative. If that could be modified, have some more integrity in that selection process, those pieces together, I think, would really improve the process.
Thank you. Thank you, Mr. Chairman.
Senator Kennedy asked a good question. We've tried to follow through on it as to just what were the verdicts or the settlements in these cases. Some of it is hard to come by very quickly, but there was one case in Missouri that was $4.69 million for a group of 20 claimants, reduced on appeal to $2 billion, to give you a range here. But remember the offer from Johnson Johnson through LTL was for $8.9 billion for 60,000 claimants. Put that in perspective.